Good afternoon, everyone. I'm Hüseyin Dişli, Vice President of WOLAS. Thank you for joining us today on the eve of Global Sumud Flotilla's departure from Tunis. The flotilla is a civilian mission, the largest of its kind since the siege began in 2007. And this flotilla will see dozens of vessels from over 40 countries sail to break the illegal blockade on Gaza and deliver urgently needed and life-saving humanitarian aid. As well as together with Global Sumud Flotilla, Gaza Tribunal, and National Bar Association of Tunis, we organized this symposium to examine the legality of this action, the illegality of the Israeli blockade, and responsibilities of the states, protected status of the vessels and passengers sailing in the face of ongoing Israeli genocide committed against Palestinian people in Gaza. We gather not just to speak law, but to stand with those who sail for justice. I speak today on behalf of WOLAS, a global network of lawyers and legal academics based in Istanbul, working to expose and challenge injustice wherever it hides. This humanitarian mission of Global Sumud Flotilla is a continuation of the global will to deliver humanitarian aid to people of Gaza by challenging the unlawful Israeli blockade. Since 2007, several missions has been conducted. Dozens of UN reporters has stated for the flotilla mission of 2020 is also at stake for this mission. I quote, "The flotilla is a material manifestation of international support for the ongoing Palestinian struggle for freedom and self-determination, and the internationally recognized right to receive humanitarian aid without interference or hindrance." Quote end from UN reporters. Just like the previous flotillas, this flotilla's demands are very clear: immediate and unconditional and permanent ceasefire, unrestricted access to humanitarian aid, and an end to illegal blockade of the Gaza Strip. In March 2024, the International Court of Justice, through binding provisional measures, determined that the killings, displacements, conditions of the famine and starvation in Gaza amounted to a plausible risk of genocide. Under the Genocide Convention, and accordingly, the court issued strict provisional measures against Israel in January, March, and May. In November 2024, International Criminal Court, ICC, issued an arrest warrant for Benjamin Netanyahu for the war crime of starvation as a method of warfare as well. But after that, and just like before that, these decisions didn't change anything, yet Israel brazenly escalated its criminal policies by declaring numerous times a complete ban on the entry of all goods into the Gaza Strip. An unambiguous act of collective punishment and flagrant repudiation of binding international legal obligations, carried out in an open defiance of ICJ's authoritative orders and ICC's prosecutional mandate. What's worse, Israel doesn't only use starvation as a method of warfare, but also using humanitarian aid as a method of warfare. As all of you know, the so-called humanitarian aid mechanism imposed by Israel and US, so-called Gaza Humanitarian Foundation, is a death trap, one that instrumentalizes aid, instrumentalize aid to displace, humiliate, and confine the civilians. It's obvious that international law is currently failing and has historically failed. Historically failed Palestinians since 1948. The ongoing Israeli genocide in Gaza, 7 years of ongoing Nakba, 77 years of incremental genocide, 77 years of apartheid, dispossession, and denial of basic rights and freedoms. Gaza took off the masks and shown us a very well-known truth by some of us, by probably all of us in this room. Today, international law can no longer be seen as merely a discipline that addresses the crisis. It has itself become a discipline in crisis, as a respected scholar, Nitina Tzovola, wrote in one of his recent articles. Therefore, when we reflect on international law, we must not only approach to law as a mechanism for resolving and regulating disputes and crises, but also examine it critically, its roles as a producer and perpetrator of this very crisis. The genocide in Gaza also cannot be decontextualized from the systematic oppression endured by the Palestinian people since the Nakba. It's rooted in a broader history of colonialism. The colonial domination and alien subjugation that Palestinians are exposed to is not an isolated event, but part of a continuum that reflects the persistent influence of colonial structures on contemporary international law. Gaza has shown us very clear that there is an urgent need to dismantle the colonial structures and mechanisms born of them. This includes challenging the so-called universality of international law, which often masks Eurocentric and state-centric biases that marginalize non-Western perspectives or global South perspectives. The genocide in Gaza has exposed the limitations of this universal so-called legal order, particularly in its failure to protect colonized people. It has underscored the urgent need to rethink international law, particularly in the context of decolonization and right to self-determination in the sense of full sovereignty over the sea, land, and air, as well as societal catharsis. Even today, almost 2 years into genocides, states are failing to meet their binding obligations under international law to prevent, halt, suppress, and punish genocide, and also the starvation imposed by Israel in Gaza. States are today aggressively policing refugee movements, yet they didn't show 1% of this effort to police genocide. Instead, many states still supply Israel with weapons, resources, and political cover, conduct that may amount to complicity in international crimes, including genocide. In response to this failure of state responsibility, civilians such as those participating in this flotilla are engaging in a lawful direct action to safeguard and realize Palestinian people's fundamental entitlements under international law. It is in this legal and political vacuum created by the states and actors who has capacity and responsibility to prevent happening of this grim picture before us today. It is this vacuum that when it is the familiar motto of the previous missions, when states fail, we sail. That's exactly, that's a very good definition of the vacuum that is the motivation behind this very mission as well. I've been serving Freedom Flotilla Coalition as a legal advisor since 2024. In every mission or our attempt for sailing, Israel did everything to sabotage the mission, tried to scare away the flotilla participants, failed. Then launched all kind of bureaucratic warfare to stop flotilla vessels before sailing. Israel utilized its influence over incumbent or potential flag countries, port countries, since April 2024, waged threats on them, but only on them, not only on them, but also authorities registrating vessels class, insurance, etc. A number of times flotilla flags has been withdrawn by flag states. and some of ships were with 800 to 1,000 passenger capacity. That particular ship, Akdeniz, sadly, is still waiting to obtain a flag from a country willing to grant it. A number of times, as I said, eventually with the conscious ship failing to stop it before sailing, Israel directly attacked the ship, endangering the lives of passengers around 2 nautical miles to Malta. When all this happened, we announced that we will sail sooner than sabotagers are expecting. And now we are sailing as Global Sumud Flotilla in an unprecedented manner. We sailed, we are sailing, and we will be sailing until Palestine is free and fully sovereign over its land, aerial space, and sea. I know this was a little bit of a detour. I was supposed to present the legal memorandum, but I thought suffocating the whole room with legal technicalities, which is characteristic to law, the law that Franz Kafka himself making you feel like chewing a sawdust. So I wanted to save you from that as much as possible. I'm sure I did you a favor. So instead of presenting the legal memorandum from beginning to end, which we have written with my respected colleagues, and the reports will be soon, memorandum will be out soon in the Global Sumud Flotilla website. So for the scholars and lawyers and all the passengers, it's always there as a reference. Instead of that, I would like to just present the central arguments and the critical points in the legal memorandum. Of course, the legal memorandum is for and foremost answer the question of why this mission is lawful under international law. And in order to do so, since the very phenomenon of blockade justifies this vision, the memorandum starts with analyzing the illegality of Israeli naval blockade over Gaza, which is exercised since 2007. Israel's naval blockade imposed on Gaza since 2007 is unlawful. I don't want to give premises, but it's just, this is not very orderly premises, but for my mind organization, forgive me, I need to articulate. Argument one, the vessels, as you know, are primarily subjected to jurisdiction of their respective flag states. Potential interception of these vessels by any state on high seas amount to violation of the sovereignty of the flag states and unlawful use of force under international law. We have witnessed this with the recent Medellin and Handala attacks. Since there are criminal filings in the UK, hopefully they will be prosecuted properly on these crimes, since it is the extension of UK territory, since the ships were carrying UK flag. Since the one of the accepted arguments in armed conflict in the sea is that naval blockade applies to international law, international armed conflict. And in order something to be international armed conflict, it should be between states. Given that Israel doesn't recognize Palestine as a state, I am now just actually deconstructing Israeli argument. Israel doesn't recognize Palestine as a state, yet claiming for naval blockade. Of course, it doesn't matter if Israel recognizes Palestine as a state or not in order for international law to characterize a blockade legal or not. But here is the thing, from Israel's viewpoint, the very category of blockade, non-existent, because not recognizing Palestine, at least it is incoherent with itself. This is not one of our central arguments. I just wanted to start with an awkward Israeli position. For your information, in the Turkel report, which was written by Israeli commission right after Mavi Marmara attack, which was, if I'm not wrong, 4 volumes, the whole argument was, despite we don't recognize Palestine as a state, why naval blockade applies. They were trying to create this exceptionalism and trying to argue that, well, that ship sailed, now the nature of armed conflicts changed, so it should be a thing, and there is a so-called significant state practice about prize issues in the sea, and in last 100 years only there are 3 state practice, and one of it is Israel, so it's also tautologic to justify something with state practice by your very own state practices. This is just one thing. So we started with the total awkwardness, and I wanted to start with invalidating that. So if you ever talk to an Israeli legal scholar doing maritime law, the main argumentation will be around this. And in this case, when blockade is not a category, applicable legal framework will shifts to the law of the sea. Argument 2, now setting aside the nature of the armed conflict in the sea, it is still, Israel insisting on exercising naval blockades is still fallacious and basis under international law, because Palestine, as acknowledged 2 times in the WOL Advisor Opinion and 2024 19 of July Advisor Opinion, Gaza is occupied. Palestinian people has a right to self-determination, and customary international law prohibits all forcible measures against people's self-determination. Consequently, Israel's sustained enforcement of control over land, sea, and air in Gaza using forcible means constitutes a continuous breach of international law. That's why, since the framing of the questions to ICJ for the advisor opinion in 2024 wasn't particularly about the naval blockade, of course, in the analysis, in the advisor opinion, naval blockade wasn't engaged in. But if it was, what we have in the advisor opinion is enough to extend the argument that advisor opinion by extension acknowledged the blockade as illegal, because, as I said, international law prohibits all forcible measures against self-determination, people's self-determination. Argument 3, now going into more technical. Interestingly, this is an argument from London. Declaration concerning the laws of naval war. This is London Declaration from 1909. So, following the conflict, now Gaza is occupied Israel is occupied force in Gaza, which is acknowledged by advisor opinion as well, thereby unquestionably subjecting itself to the law of occupation. As an occupying power, Israel is precluded from applying the blockades to these areas. I know this is an interesting argument because it's coming very interesting colonial place. Moreover, beyond the illegality of continuing the blockade, under these circumstances, Israel has not only obligation to permit relief schemes, but also facilitate them by all means at its disposal. Why, as an occupying power, Israel is precluded from the blockades to these areas? The Declaration concerning laws of naval war, London, Article 1, actually stipulates this. Even the most colonial legal, an attempt to codify the customary international law states this, because the focus wasn't really about settler colonial context like Israel. The focus more like by codifying the naval warfare law, in fact, actually, it's operated as a judicial instrument of imperial consolidation, a technocratic veil for securing Euro-Atlantic maritime hegemony. By the time there were colonized regions and there were colonizers, but for the supply to go on, there was huge need for neutral states. And arbitrarily intercepting the ships of these neutral states was harming the very colonialism and capitalism. So in order to secure a stability to capitalism, in London Conference, the colonial powers stipulated that in order to protect the supply chain, if you're occupying a land, you don't need to apply a naval blockade because it's absurd, you're already on the land. So this was more like protecting the maritime mobility. Of course, London Declaration is not the central legal reference. It is more like Sandre Memorial. We will come to that. Okay. So do you need to go or shall I just wrap up? Okay, I'll wrap up. Okay. I still have 20 pages, but yeah. No, just joking. Okay. I'll be quick and then we'll be in more basic terms and only will go technically when it's needed in last 5 minutes. Under international humanitarian law, as we know, and the law of sea, naval blockade is prohibited if it inflicts disproportionate harm on civilians. It has the purpose or effect of starvation of civilian population. If it prevents access to humanitarian relief. This is San Remo Manual on International Law, Articles 102. This is, of course, a restatement of customary international law. And Fourth Geneva Convention, to which Israel is a party, whether it's a customary law or convention, doesn't matter, Israel is a party, prohibits collective punishment, and additional Protocol 1 forbids starvation of civilians as a method of warfare. So the very practice of starvation as a method of warfare invalidates the naval blockade as stipulated in San Remo Manual. Thus, the relevant legal body to apply, legal framework to apply to our situation is not IHL or armed conflict, it is human rights law. We are civilians, this is a peaceful mission, and the mission's main aim is to provision of humanitarian aid to Gaza, which was already in the provisional measures of the ICJ. So Israel's unlawful blockade has been condemned also various times by UN bodies and experts. I'm not gonna go deep into law of the sea, but in brief terms, our mission has a right to freedom of navigation because it falls under none of the exceptions in UNCLOS 110, such as piracy and smuggling or carrying the same flag as the belligerent party or unlawful broadcasting. None of it applies to us. Thus, our mission has a right to freedom of navigation. Secondly, since it is neutral to any state on the route of our journey, since it's a neutral and non-political to the coast states that we are passing through, the mission itself has also right to innocent passage. And thirdly, we have a right to humanitarian passage. I'm sure Luigi will actually go deep on that. That's why I leave it here in terms of law of the sea. And in short, why this mission is lawful? The blockade is illegal. Therefore, any use of force by Israel to enforce it is also unlawful. Breaching such a blockade or challenging to deliver humanitarian aid in itself a lawful act. The mission is humanitarian, carrying aid, no arms. It respects navigation law, exercising freedom of navigation and innocent passage rights. and while there's no unclosed exceptions, participants are protected civilians as well, even given the interception if they are abducted by Israel under Geneva Conventions. So they have to be treated humanly, and Israel should refrain from mistreatment or degrading treatment. Okay, now I conclude with what is going to happen if the ships are intercepted. First of all, there is flag state obligations and the flotilla is sailing under a number of flags, countries' flags, and they have sovereignty responsibilities and mechanisms against Israel. Secondly, home state protection. Every citizenship is Israel needs to allow all the legal visits and consular visits and legal support to passengers by the relevant consular authorities under Vienna Convention, Consular Relations, Article 36. Universal jurisdictions, any war crimes against humanity or genocide, any action falls under this, can be prosecuted in many countries around the world. And international accountability, we are already preparing an ICC file about conscious Medellin and Handala attacks. If these ships are intercepted, this will be in the same application to ICC, and we will make sure that our filing will be communicated to every ICJ judges. As concluding, I would like to say that I would like you to know that we are working closely with a number of governments, and we are mobilizing legally and diplomatically. We are mobilizing the word diplomatically and legally. And the measures and legal accountability mechanism I just stated will definitely be followed. Lastly, for the passengers, we need thousands of eyes for every passenger on the ship. So their mind should be at peace. For every passenger, we will be thousands of eyes, arms, and voice. And finally, I extend my deepest salute to heroic people of Gaza. You set such a precedent that they took the mask of all the oppression and hegemony in the world. And you resisted, and you shown what resilience and resistance mean. You resisted against, and have been still resisting against a colonial subjugation and alien domination. And under this weight of devastation, you continue to unmask the hypocrisies of global political system and international law, strip bare facade of liberal humanitarianism, and inscribe a new precedent in a grammar of liberation. Your endurance is not only a defiance of injustice, it is a word historical assertion of life, dignity, and refusal. Gaza is not merely enduring, it is teaching. Assalamu ala arwah shuhada. Thank you very much for listening to me.